I'd like to introduce Louise Hicks. She's the barrister that's been representing Moorabool Shire around this matter. Louise has over 30 years of experience in law, including 6 years as a partner at DLA Piper. She regularly appears in Supreme Court at VCAT and before ministerial panels and advisory committees in planning and environment matters, including restrictive covenant disputes, planning, merit cases, and Water Act claims. She's continued to develop a wide-ranging practice in all of these matters and has gained experience in various VCAT lists, including other civil lists, including the owners' corporation list. I will flag, so Louise is going to speak to us remotely, so she's online, you can see her right now. I'll hand over to Louise, and welcome, Louise.
Yes, thank you very much indeed. Thank you very much indeed, and good morning to everyone. I'm so very sorry that I couldn't join you in person today. I would have loved to have done that. I'm in WRL. You might have heard of that project for Moorabool Shire Council, and we're back in that hearing today. And so I have to be there at 11, and so I will give my keynote address to you and then straight down to WRL to continue the good fight there. As the Mayor has indicated, I had the privilege of representing Moorabool in the matter of the dumped cylinders at VCAT. And it came on top of a real growth in my practice in environmental law as well as planning law on the question of dumped material. I started to notice this in earnest, I would say, about 2 or 3 years ago. I started to get a whole suite of matters coming across my desk from clients who had been the unwitting recipients of material. In one case, a local council had the misfortune of taking on some materials to help fill some areas relating to a recreational facility. And as one often does, you get approached by people saying, I've got clean fill. Do you want it? You can actually have it at no cost, and maybe it'll help council with this project or that project. So that's where it really started off. And whilst I'd had a few cases like that from time to time, I've really seen an upkick in that type of issue in the last 2 to 3 years. The first thing I would say to you is that if anybody ever offers you clean fill, firstly, there is no such thing as clean fill. And secondly, do not take it. You are taking a liability and you are creating a legacy. So that's where I started to see this fill issue, this dumping issue. I then started to see it in planning cases. So a lot of the time I'm in VCAT or ministerial panels, and I started to see a real flow of enforcement action where somebody had filled their land for X or Y reason, sometimes for the creation of a platform to build upon, for a whole variety of reasons. So there were some enforcement actions coming over going, well, hang on, that's earthworks. You've got to get a planning permit for that. And then I started to see planning permit applications to get out ahead of projects about fill. And they are ongoing. And I'm waiting some decisions from VCAT on some matters that, given that they are currently before VCAT, I won't discuss in any detail. But from that, I saw that there has been a real problem created, and it's now coming to the pointy end, and has developed over those years, those last 3 years in particular, a real problem created by the regulatory framework as it relates to waste, fill, the categorization of same, the regulation of same through the EPA, and the sheer cost attendant on disposal of anything, including cat C waste. So that's where we were. Now the piece that I'm seeing is what you're all here gathered to talk about today. So what I'm now seeing, in addition to the offers of clean fill, the enforcement action, the planning permits trying to get rid of this, it's variously called fill, spoil, waste material from major projects. Of course, there are many in this state at the moment. What I'm now also seeing is why you're here today. So I'm now also seeing the dumping of fill, spoil, waste of any and every kind throughout the state. And it's being driven by the complexity of the regulatory regime, and it's being driven by the cost of disposal of the waste. As the mayor indicated, with the particular problem that Moorabool faced recently, there is only one place in Victoria, up in Stawell, so welcome Swan Hill, that is regulated, that is permitted to take this kind of waste. So you've got not only the one place that will take it and charges accordingly, but you've also got the OH&S components around the loading of the waste onto a vehicle to get it to Stawell, and that all has to be done safely, and all that costs a great deal of money and must be dealt with very, very carefully. I'll come back to that. The other aspect of the regulatory regime, the legal regime that is leading to the complexities you will be discussing today, is that acknowledging that heavy set of complex regulation of fill, material, spoil, and waste, there is, on the other side of the coin, a rather straightforward and unnuanced approach to liability. What I mean by that is that under the Environment Protection Act, it is more often the case than not that what I call my suite of innocent owners or innocent occupiers are caught up in the liability net. Under the Environment Protection Act, the EPA has carte blanche to choose from a suite of people, entities, or companies to serve a suite of notices on. There are environmental investigation notices, which are, I'm the EPA, I need to know more about what's going on. And then there are environmental action notices, which is, I want you to do something. And those notices can be served on a suite of people, and there is no hierarchy to that suite. So albeit the Act was, prior to its amendment in 2020, 2021, effective 2022, was and remains supported by certain principles or pillars, the principle of which is said to be polluter pays. And you'll be aware that that is it's often referred to as, oh, it's a critical element of environmental protection and waste management, that we have this concept of the polluter pays. The entity, the person who generates pollution and waste, should bear the cost of containment, avoidance, and abatement. And you'll see that in section 17 of the EP Act. That's all very well and fine. But the difficulty comes when one actually puts that principle into action. If the legislation were really to be about polluter pays, it would say in the enforcement section, so to whom can I serve a notice? You would have polluter as the number one entity in the hierarchy. And only if the polluter could not be found or could not be established or didn't have any money left, which is often the case, only then could you move on to the next person on that hierarchical list. That is not how it operates, in fact. So the concept of polluter pays, a lot of my clients come to me and say, I'm an innocent owner. I didn't dump this waste. It's got nothing to do with me. Why am I getting this notice? Isn't it polluter pays? Isn't that the underlying principle? It is one of the principles, but in practice, there is no such hierarchy in terms of who can receive a notice. People who can receive a notice, yes, it can be the polluter. It can be an innocent owner or occupier of land. It can be a person who's allowed the dumping of waste on their land. So, hi, I've got some clean fill for you. Oh, great. And you allow that onto your land, you would be said to be permitting that. And that's another person who can receive these notices. But it doesn't have to be in order. The EPA doesn't have to say, all right, who is the polluter? Can I find them? Can I establish that they are the polluter? And in some circumstances, that can be a bit tricky, where you've got multiple dumpers in a particular area or multiple contaminators, so that can be problematic. Having gone through that exercise, does that entity have any money? The EPA doesn't need to do that. The EPA just goes, oh, there's some waste over there. First call, if it's on the roadside, that was the situation that the mayor was talking about. First call, straight through to council. Hello, council, is that your road? Are you the owner of that road? Do you manage that road? Person who picks up the call from council. Just let me check. No, it's not a Vic Roads Road Department of... No, it's us. Yes, it's one of our roads. The next thing you'll get is a notice, because all the EPA has to establish. So the first contact will always be, are you the owner or the occupier? They'll not put it quite like that. They can serve you a notice asking you that same question, but more often it's the phone call, it's the email. Hey, by the way, is that a council road? Is that a council reserve? Are you the committee of management for that particular reserve or Crown land? That's going to be your first contact from the EPA. And as soon as they find out that you are an owner of land or you're an occupier, that's normally where the grayer area is. So an occupier, no longer defined under the legislation, but drawing from case law, tells us somebody who's in management and control. So then you have to think about all your Road Management Act business, but watch out for that first phone call, because that's the point at which, if you start saying, oh yes, no, yeah, absolutely, we manage that road, you're then an occupier. And the EPA does not need to go to the polluter first, exhaust all of that before they come to you. They can come straight to you, as was done in this case. You get the environmental action notice. It will have very, very strict timelines on it. And depending on the nature of the waste, we had a particularly problematic, lots of safety issues waste. But you'll generally find these environmental action notices are quick. They call for action quick. And when I come to talk about the VCAT action that Moorabool took and the stay that we sought, you'll see how that quick action becomes highly problematic for you as a council. The other thing you'll see in the notice is language such as you're storing industrial waste at a place or premise. If you get a notice that has words like storage, industrial waste, all of these things can be challenged from a legal perspective. So notices can be challenged. They have to be done in a timely way. But if you see language like storage, if you see language like industrial waste, those concepts can be challenged to at least give you some time to consider your range of legal actions. So the notice we got was addressed to us as the current owner of the land. That it was said that we were storing industrial waste. And you can imagine the arguments that we sought to raise. We're not storing anything. We didn't bring the waste onto our lands. There was then the question of whether it was industrial waste or not, and that's a whole set of regulations. But the first thing we had to do was to try and get a stay on the operation of that notice. Because quick. And so we had to get a stay on the operation of the notice so that we could then make the arguments, storage, occupier, industrial waste, etc., etc. We were refused that stay. So that essentially meant that we could not take the arguments about the environmental action notice any further, because the time allotted by VCAT for the hearing of the further was after the time for compliance of the notice. So we've just gone the hamster wheel there. And so council took the action that it was necessary for it to take. So you can see that there are considerable restrictions on how useful the apparent rights of review of these notices are to you. It was interesting, however, that in the VCAT decision on that question of stay, which is where we had to start and where regrettably we had to finish, given we didn't get the stay and therefore could not in a timely manner argue further about the notice. It was interesting to note that VCAT made specific reference to another of those core principles in the Environment Protection Act. I've spoken to you about the polluter pays principle. VCAT made reference to the concept of shared responsibility pursuant to Section 16 of the Act. And you get very used to reading judgments or rulings of the tribunal to hear what language they choose to use. And by raising this, that, in my view, was VCAT saying, come on, EPA, shared responsibility, come to the party, be more proactive, share responsibility for this problem. Now, that's a piece I think you can, in discussions today, really think deeply about. Derek will speak to you more on that, I have no doubt. But that VCAT has opened a door there in terms of the ruling in that particular case, making reference to shared responsibility. And I think it's a door you can slam open and see whether you can, through that principle under the Act, seek to achieve change more broadly. And one of the changes you might want to discuss today would be, the Mayor's already alluded to it, a legislative change that brings into operation that hierarchy that I spoke about at the beginning. On the polluter pays principle, that hierarchy, you need to change the Environment Protection Act to do this. But New South Wales does it. It's not rocket science. You have to go in order so that you don't, as the EPA, go straight to the owner and occupier. Innocent by that, I mean, had nothing to do with them at all. First, think about that legislative change, because if it was that the EPA had to go to the polluter first and exhaust any and all regulatory action against that person or persons, then that will help your position both legally and from a negotiating perspective through this concept of shared responsibility. You will also have to think about, in any such proposal for legislative change, you'll want to retain what follows under the Environment Protection Act once you have expended the monies that the Act does provide for, and you'd want to retain this, that having expended that money, you can turn to the polluter for recovery of any and all reasonable sums expended in compliance with the notice. I'd like to look at that piece for a few minutes. So the Act provides statutory rights to you over and above your common law suite of rights, negligence, nuisance, trespass, etc. The Environment Protection Act also provides that if you do get one of these notices and have to act upon it, as was the case here, as an innocent owner or occupier, you can then turn to the polluter to recover those costs. Sounds fabulous. In practice, highly problematic. So when if you are thinking about a proposal for legislative change and lobbying for that, you will no doubt be met with, well, I hear what you say, but it's not all bad news. As an innocent owner occupier, you have under the Act at the moment the right to turn to the polluter and recover. So it's not so bad. And we get met with that all the time when we try to persuade the EPA, no, don't serve us with a notice, send it to the polluter. They'll go, and I'm paraphrasing, obviously, that's all a bit hard. First of all, we'd have to do the work to find out who the polluter is. And then second of all, we'd have to actually establish that they are the polluter. It's all a bit difficult. So I tell you what, I'll serve you with the notice and then you can do that work. So once, and you can only seek that recompense after you have expended the money. So the money has to go out your door first. And once that's all expended, you're $500,000 down, plus legal costs, become expensive. You can then turn to the polluter, but only after the money's out the door. And as the mayor's alluded to, that can break councils. Have you all got $500,000 plus your legals hanging about? And so that's problem number one. Problem number two is establishing that somebody is the polluter. And that's a whole series of proofs, evidentiary proofs that you need to put together. Then you need to establish whether or not it's worthwhile chasing that person or entity for the recovery of your money. Because you're going to need to go to the Supreme Court, and already you're very expensive in that jurisdiction, even more so than VCAT. And you're in a costs risk position in the Supreme Court that you're not so much in VCAT. And so you're going to have to do your due diligence to say, look, has this person or entity got any assets I'm going to be able to attach if I even get a judgment in order to make that course of action worthwhile. That's as I see the challenge. I hope that I've given you some things to think about from a legal perspective in terms of your next steps, because I was very keen in this presentation not to be just about the past or just about the problem, because as the mayor said, we are here to try and figure out some next steps, and Derek will speak about that as well. And so that's your shared responsibility, Section 16, and your legislative change about the hierarchy to accord with polluter pays. But I also, in the 10 minutes left to us together, for I have to run, I wanted to leave time for questions, because I feel that I can probably be of most use if people have some questions of me that we can get the ball rolling, and you could then expand upon in your next sessions.
Thank you, Louise. So as per Louise's advice, she's normally very expensive. So we've got an opportunity right now to get some free legal advice. So don't be shy with your questions. We have got roaming mics. So I believe someone down the front, a couple over here. And I also believe that if people have questions online, we'll be taking those. And Louise, the roaming mics will read those questions out for you. So Louise, just let us know if you can't hear the questions.
Certainly.
Yeah, Louise, in this situation, it looks like the EPA failed to act because I knew where it was in the first place. Does Moorabool have any rights to retain the amount they spent from their EPA levy that they would be paying? So basically retain that money. due to the failure of the EPA to act accordingly?
Yeah, so firstly, you'd have to establish that they failed to act. And you can imagine the kind of responses you'll get there in terms of ongoing investigations, can't talk about that, all very confidential. Then you have to employ all your FOI tools to see what's going on. There is no legislative basis to link that then to the levies, in my view, albeit there would be considerable negotiating power, one would have thought, should that connection be made between an ongoing problem and the EPA's acts or failures to act. So FOI can come in handy there.
Thank you. Amanda Dodd from City of Whittlesea. How far up the chain do you think we can go with the polluter pays principle? Often there's middle people who collect the material from the actual people who've generated the waste. Often they're small people, shelf companies that are just basically the transporters. How far do you think we could go up the chain and look at that kind of chain of responsibility under that polluter pays principle?
You can follow it all the way to the top. So the guiding principle is the generation of waste. So it's a sort of cradle to grave environmental regime. So you can follow it all the way up to the top. Who created the waste? But you're right. You touch on a really important point in relation to where do you put your enforcement or your recovery efforts, your legal efforts. So the way I would look at it is you put together the chronology, you put together who's involved, because the list of persons that are potentially liable are the top of the chain polluter, he, she, it that creates the waste, together with those that dumped, together with those that allowed the dumping to occur, and that can be an implicit allowing. So you can follow the whole chain, the Act would permit that, and then you would do your due diligence as to where am I going to spend my effort, because there's really no point in chasing unless there's something at the end of it to attract, as you've alluded to in the $2 example.
Thank you, Louise. Just a question about, I suppose, where you think the next step is for this collective here, because in Moorabool's case, we went to VCAT and we tried to apply a stay to give us opportunities to look into the matter further. We then applied the FOI tools and that wasn't successful. So all of a sudden we ran out of options. So if in the time that's left, if you gave us advice as a collective about how we bring about change in this area, so there's not more councils that are left with a similar situation, what would that advice be?
Yeah. Yes, thank you for the question. What you are doing in banding together is critical. It's just going to be too easy to pick you off one at a time, dependent on who, because people, in terms of dumping, as you know, and I'm telling you how to suck eggs, people forum shop. You know, what's the council where I can dump today? Oh, it's getting a bit hot in Moorabool, I better think about dumping somewhere else. They seem to be, you know. So people start forum shopping. So unless you stand together with a position to the EPA, to the state government, you'll just get picked off. And who gets the dump material will change over time as people forum shop, municipality shop, to see who's not so hot in terms of who's not got that focus on them, and who's not perhaps as hasn't had the problem before, and hence it's not on their radar. So absolutely band together, keep banding together, and approach those that can assist in terms of the putting together of funds to solve this problem. Pick up that Section 16 shared responsibility, and pick up the polluter pays principles, and use that to affect change. And I think that the change will be the establishment of a fund similar to the United States, way back in the day, set up a contaminated land. They called it the Superfund. And I mean, that's decades ago. And it was born out of an understanding that there were lots of innocent occupiers and owners who were dealing with legacy issues, in that case, contaminated land. But I think the same could be applied here in terms of waste. And the government, the federal government, decided that they really couldn't keep bankrupting people or making insolvent companies to deal with legacy issues, and they put together a super fund. So, and that fund is then funded through levies. In this case, you might do it through the waste levy, to put together a fund to be drawn down upon in circumstances such as this. So that's stand together, think about a fund, and the way to get there would be the shared responsibility and the polluter pays concepts.
Thank you, Louise. Councillor Berry from Moorabool Shire. Very informative. Can the company who was the original owners of these cylinders come into the equation and be responsible in some way, considering a lot of these cylinders have branding on them?
Yes, that's a really interesting question, because again, thinking about that cradle to grave, so the legislative regime is about responsibility from the creation of the thing to the end product and the proper waste disposal of the thing. It should be a closed loop liability circle. That's the idea anyway. And so, yes, there is available a legal point that depending on the contractual arrangements that company entered into with the waste receiver and disposal person or entity, what due diligence was done prior to entering into that contract, and what due diligence was done by the company to ensure that its obligations as to closed cycle waste disposal were being properly undertaken by the person they contracted. So you can't contract away that liability. So that there is a legal avenue that could be explored there.
You've really prompted people to start asking questions, Louise. So I believe we've got a question online, and then we've got one question.
It'll have to be the last one, but can I make this suggestion? Can you, in the course of the morning, gather up any questions that got a legal bent to them and send them to me? So when is your lunch break? 1 o'clock?
I believe we'll be breaking at about 12. Yep.
12? All right, so what you can do is, if you can gather up those questions, email them to me, and I'll do what I can to give you some input on those questions. I don't want them to go by the wayside. I'll see what I can do by email, if that would be of any assistance.
No worries. And so we might keep the online questions because we've already got them documented, so maybe we'll finish over here.
Thank you.
Yeah, my question was around the collection of it, because obviously in this case the EPA were already aware of this waste, whereas a lot of the time when this is dumped they might already be aware. We'll be the first ones to find it, and typically waste in a road reserve our crews would pick up and take away. What do we need to be aware of from a legal perspective around undertaking our normal day-to-day operations to not accidentally take responsibility for waste with crews who are not intimately aware with the classification of waste under legislation? And everything. What are the pitfalls that we need to watch out for in those operational aspects?
Yeah, so OH&S is a huge issue, because more often than not, in amongst spoil and fill, there's asbestos. That's why a lot of stuff is dumped. People go, oh, that looks like a piece of asbestos. So there's a huge OH&S component to that very scenario. And then there's the liability of taking into possession. You're now in management and control of that material. And so all of the legal obligations kick in around the proper disposal of it through the regulatory regime that requires it to be categorised, and then the appropriate waste disposal facility found. So there is a whole suite of liability that you inherit as soon as you touch that material. So if it is that your road crews are finding this stuff, they need to notify somebody within council immediately who can then take up the necessary communications with the EPA and any others, because you've got a duty to your employees, and you've also then got the duties as soon as you take a possession of it. Never mind what you've already likely to be argued is it's on your road reserve, and therefore you're already in control of it. So stop, don't do anything, certainly don't touch it. Make contact, have somebody in council who's the point person for the citing of this material. What do you do next?
All right, thank you very much, Louise.
You're very
Greatly
welcome. I gotta
appreciate
go.
it for your time. No worries. Thank you. Good luck with your work today. Thank you.
Yes, thank you very much.